감사합니다. 이제 오늘의 마지막
Thank
이번
you.
컨퍼런스의 마지막 세션인
Now
올
we
세션을
will begin
시작하도록
the fifth
하겠습니다.
session, which is the last session of the conference. In the fifth session, we will be covering the topic of artificial intelligence. And this session will be moderated by Mr. Lee Kyuhong, Chief Researcher from the Judicial Policy Research Institute of Korea.
큰 박수
Please give
부탁드립니다.
them a big round of applause.
예, 방금 소개받은
Yes, as introduced, I am Lee Kyuhong from the Judicial Policy Research Institute of Korea. And let me introduce to you what this institute is about. Well, in Korean, I feel bittersweet about this conference because we have been having in-depth discussions from yesterday till today, and we have had heated discussions and we have seen delays because of the heated discussions. I'm very happy to be part of this. And JPRI, the institute that I am coming from, is like the US. Is unlike the FJC. I mean, the FJC is doing both the training and the research, but then the JPIR is the research-focused research center that is under the Supreme Court. And this research center is focused on research, and the training is done at the training, a separate training center. We have around 10 doctor's degree researchers, and we also have 10 double-heading judges in place so that they can make the blueprint for the future for the judiciary system in Korea in the mid to long term. And one book of the roadmap is up to like 200, 300 pages, and we have published multiple multiple books so far. And I've worked at the Korea IP High Court for 6 years, since 2013, and I have always attended the conference. And in 2020, in 2021, even though there was COVID, we have been holding this conference every year despite all the difficulties. And Judge Kent Jordan, yesterday said that he joined this conference via Zoom remotely, and Judge Richard Mead also joined this conference via Zoom around, I think, 2021. But then due to the time difference, you must have had a lot of difficulties. And I once again want to thank all the participants who came to this conference before, even via Zoom. So those two personal notes were something that I wanted to say before we jump into the session 5. So we have 4 distinguished panelists for this session.
우선 소개를 시켜드려야 되겠습니다.
Let me introduce them to you. First of all, we have Judge Jörn FEDDERSEN from Federal Court of Justice in Germany. And you have met him in the earlier session today, but once again, please welcome him with a big round of applause. And we have District Judge Kiyo MATSUMOTO from the United States District Court for the Eastern District of New York. You have met her in the morning session, and she must have left you with a big impression. Please welcome her with a big round of applause. And we have 2 judges from Korea, and they are in charge of 1 part each. First of all, we have a presiding judge, Young-Eon, from the Daegu District Court of Korea, who will be dealing with the IP part. I was part of the same panel with him, and the Paris Paris University LLM is the degree that he has, and we also have Bowon, the judge from the IP High Court of Korea. As you can see from the profile, he has studied multiple fields, and he also received LLM from the US's George Washington University. So today's topic is artificial intelligence. AI is a buzzword in all the conferences that are held recently. This is such an important topic. And the development is happening at a rapid pace, and we cannot even imagine what will happen in a week's time. And that is why that if there are legal discussions involved in it, not a lot of discussions are at a mature level yet. Only a few cases held in the US and not many in the world. So we would like to talk about this topic very specifically. So in the earlier sessions, we had a lot of practical discussions, but in this session, we won't be able to have a lot of practical discussions because this is so recent. And the reason why this is in the last part of the conference is because of that aspect. We would like to look at the topic from a future standpoint. That is why this is at the last part of the conference. But as said, in the large law firms, this IE's use could lead to a leakage of information to the outside, so they are worried about it. And in the smaller, law firms, junior, attorneys are using this very aggressively, based on what I heard. And in the Judicial Training Conference, what we say is how we can prevent abusing the AI to the junior law practitioners, legal practitioners. But based on what I heard, well, the world is changing rapidly, and a big driving force behind it is the social media. Social media is spreading fake news, and that is polarizing people. The middle ground is, evaporating, and that is based on algorithms. And the initial regulation on the social media failed. That is also a view held by some people. And on the artificial intelligence, it is exactly at the point where it is now, at a nascent stage. And if regulation is a too big a word, then maybe this is the time for us to start having a really in-depth thought about it, so that we can be prepared. So today we will be discussing two different parts. The part one is about AI and related IP rights issues, and in part two we will be talking about the use of AI in legal proceedings. And if you look at the booklet, it starts from page 416 in the English version, and in Korean it starts from page 512. So if you would like to refer to the materials in the booklet, those are the pages that you will have to remember. 416 for English, 512 for Korean. And we have thought about many different options of running the session, and as I explained earlier, this is not exactly an area that is clearly shown in the actual legal practice, and there's a lot of blanks in this space, and we need a lot of imagination to be able to be prepared for the future. So that is why we divided it into part one and part two, and I will explain to you about what the overall questions are in those two parts, and then we will be asking the questions to the judges in front in order. And at the end of the session, we will open up the floor so that we can take questions also from the audience as well. And Attorney Choi from the earlier special session made a good point about artificial intelligence, and let me summarize it for you. When it comes to determining the inventive step, according to Mr. Choi, artificial intelligence use may make it ambiguous what the scope of FOSITA should be. We will need to consider that aspect. And well, it is maybe it's too immature for us to move on from FOSITA to MOSITA. So we are, I think, at a early part of the transitional period. So I think the session is even more meaningful because we are at that timing. And well, I've been a bit lengthy in the introduction, but that is the context that I wanted to set for you. The questions are in the pages. And let me briefly explain the questions for you. Let me ask the first question, which is related to the IP cases. And these are patent, trademark, and design related IP cases. When it comes to those cases, there could be issues related to AI, and we hope the judges to introduce to us about these IP cases related to AI. And the second question is on page 475.2. When it comes to the, for example, copyright, what is going on. Fair use provision is there, and if there is any cases related to the fair use provision is something that we also gave the question about. And when it comes to the AI, I mean, the copyright becomes an issue. So what would be the ways to address the issue related to copyright? And when it comes to TDM, text data mining, is there a provision that is giving the waive to the TDM regulations? And if the royalties are paid, should we look at it from the conventional point of view, or should we look at it from an alternative point of view? So these questions are really based on the imaginative future scenarios. And we wanted to have a discussion in advance before they unfold in full swing. And the last question is around the AI-generated content and the outcome that comes out from the usage of AI. And we wanted the judges to share some of the cases related to that. So whether there are any relevant cases and the disclaimer, I think those could be an important aspect to the last question. So with regard to these questions, I would like to ask Judge FEDDERSEN, to give us the answer as a starter.
Thank you very much, Presiding Judge Lee, for your very kind and thoughtful introduction. In fact, this panel poses a challenge to me in two respects. One, I don't really have a grasp, and this seems to be a recurring topic for me, of the technical background of AI at this point. But I'm very much looking forward to the contributions by Judge SOHN and Judge KWON, because I know after that there won't be a question open. So. And the second challenge actually is that we don't have German or even European case law right now. So we are very thrilled and looking towards the United States, and I'm relieved that my neighbor Judge MATSUMOTO will provide you with quite some case law that has evolved in the United States. So thank you very much for that. We have been granted some leeway in how we structure our remarks today. Thank you for that. And I have put down what I would call a couple of speculations in my paper that you may or may not take in at some point, but these are speculations. Because the questions as to AI and patent, design, copyright, and trademark law are widely open, and answers will have to be found on a step-by-step basis, I assume, case-by-case basis. And it's such a wide field, such a wide range of topics that I decided to restrict my remarks to something tangible, right? That I can present to you as something that is already reality, at least as far as regulation goes. So I would restrict my remarks at this point and like to familiarize you with the EU regulation on artificial intelligence and its ramifications as it comes to copyright issues. But please feel free to, if you have questions afterwards concerning the first pages of my contribution in the booklet, feel free to ask those questions. Now, ladies and gentlemen, we all resent bureaucracy, right? However, at least in the European Union, we love to treat ourselves to a nice and juicy regulation. And this is quite much the case as it comes to the brand new EU regulation about artificial intelligence. And before I lay out the legislative frame, I would like to say a few words about the European Union copyright law regime so that we can put it into perspective, because the AI regulation is, I would say, not at all a copyright regulation. It is rather the case that, as I have heard during the very end of the legislative process, which is to some extent obscure on the EU level, I must say, to the very end of it, some copyright wording went into the regulation, but it is not really the core of it. So let me please, clear up a few things as far as European copyright law is concerned. This is an area of law that is quite largely harmonized by European directives, first and foremost by the Directive 2001-29, and from now on I will refer to this directive as the InfoSoc Directive, as its full name is Directive on the Harmonization of Certain Aspects of Copyright and Related Rights in the Information Society. InfoSoc Directive. Certain aspects, you may wonder, certain aspects, what does that mean? Well, in the jurisdiction of the European Court of Justice, it means actually, evolving and, an area of harmonization that is getting more and more, in size and range under the hands of the European Court of Justice. So it started with certain aspects, but we are quite far now in the harmonization as to, the idea of work, protected work, for example, which is the central notion of copyright law, obviously. According to Article 3 to 4 InfoSoc directives, member states shall provide for the authors exclusive rights of reproduction, communication to the public, and distribution. So these are the core rights of the author. And under the structure of the directive, in Article 5, certain uses are exempted from the author's exclusive rights. So you may notice we don't have a broad general fair use clause as we know it from the United States. Rather, we have quite an impressive set of a couple of exclusions, exemptions from copyright that are very specific and have a very narrow range. And I would like to mention a few of those. For example, temporary acts of reproduction that are transient and incidental and an integral and essential part of a technological process are exempted from copyright. Also, reproductions on any medium made by a natural person for private use, neither directly nor indirectly commercial. So the private use exemption. And also this exemption requires that that the right holders receive fair compensation for this private use exemption, which obviously in Europe is dealt with by the collection societies, the copyright collectives that that administer the royalties that are being paid. Maybe we will come back to that point later, because the question obviously on the table is, what about royalties for the use of protected work that goes into AI? Then we have an exemption for quotation, criticism or review, for the incidental inclusion of a work, for the use for the purpose of caricature, parody, or pastiche, and I'm desperately waiting for AI learning humor. That must be marvelous. I'm looking forward to it. And then all these exemptions only apply under the condition that the exempt uses do not conflict with the normal exploitation of the work or other subject matter, and do not unreasonably prejudice the legitimate interests of the right holder. So this is the frame set by European Union copyright law. And now I will go on and tell you a little bit about the Directive 2000. Oh no, sorry, I have to add one more exemption, which is very important in that context that we are talking about, and that is the exemption for the purposes of text and data mining. And this exemption has been added to the catalog of exemptions by the Digital Single Market Directive that was adopted in the year 2019, and it exempts for the purpose of text and data mining, and says reproductions and extractions may be retained for as long as is necessary for these purposes, and the exception or limitation shall apply on condition that the use of works and other subject matter referred to has not been expressly reserved by the right holders in an appropriate manner, such as machine-readable means in the case of content made publicly available online. So this is an important condition. As a right holder, you can express a reservation if you are able to put that in your code, of the website or whatever you are actually publishing. And also, the exemption includes reproductions and extractions made by research organizations and cultural heritage institutions in order to carry out, for the purpose of scientific research, text and data mining of works, and so on. So this is the headline, the headline text and data mining exclusion. And that is quite of some importance if we talk about how we actually get artificial intelligence going. Now, actually I'm coming to the regulation 224/1689, the AI Act. And I must tell you, I have already mentioned, it's not a copyright act in itself. So what is it? It basically has a product safety approach, if you will. Because, and I would like to cite recital 1, its purpose is to improve the functioning of the internal market by laying down a uniform legal framework, in particular for the development, the placing on the market, the putting into service, and the use of artificial intelligence systems in the Union in accordance with Union values, to promote the uptake of human-centric and trustworthy artificial intelligence, while ensuring a high level of protection of health, safety, and fundamental rights. This AI Act is effective as of August 2024. Overall applicability starts in August 2026, so we have 2 more years to get ourselves acquainted with this subject matter. Although the rules for general purpose AI models, and those are the ones that we are talking about in the copyright context, are applicable as of August next year. Now, I will tell you what the content of the AI Act actually is. Now, first of all, the regulation prohibits certain AI practices. And I will just tell you a few. For example, subliminal techniques beyond a person's consciousness, or purposefully manipulative or deceptive techniques, with the effect of impairing the person's ability to make an informed decision. You know, the idea of the informed decision is a central notion of European Union consumer protection law, and that has also found its way into the AI Act. Secondly, what is prohibited? Exploitation of the vulnerabilities of a natural person or a specific group of persons due to age, disability, specific social or economic situation, also not allowed. Also prohibited risk assessments of natural persons in order to assess or predict the risk of a natural person committing a criminal offense, based solely on the profiling of a natural person. Also prohibited creation or expansion of facial recognition databases to the untargeted scraping of facial images from the internet or CCTV footage. So this is, I would say, the catalog of the most important prohibitions that the Act actually provides. And now I will go on and tell you about the other regulation goals of this Act. One goal is to regulate AI systems, so-called AI systems with high risk. And the AI Act understands as AI systems with high risk, biometrics, critical infrastructure, education, employment, essential services, migration, administration of justice, and democratic processes. So another, if you will, restriction. Then it holds transparency requirements for certain other AI systems. For example, if I call a hotline and on the other end of the line there isn't a natural person but rather an AI-run computer system, then I will have to be informed about that fact, that I'm not talking to a human being. The AI Act creates a new authority, the AI Office, established as an agent of the Commission, that administers the regulation, has exclusive powers to supervise and enforce. So there's no private enforcement of the AI Act, at least at this point. This is a piece of administrative law, if you will. And the AI Office can set fines for infringement in the case of failures to comply with the request of the AI Office. And this can be up to 3% of the total worldwide turnover, or 50 million euros. Now we are talking, ladies and gentlemen. Okay, now what are the copyright-related provisions? I would like to start to tell you that they only apply to general purpose AI models, which are defined as including an AI model, including where such an AI model is trained with a large amount of data using self-supervision at scale, that displays significant generality and is capable of competently performing a wide range of distinct tasks regardless of the way the model is placed on the market, and that can be integrated into a variety of downstream systems or applications, except AI models that are used for research, development, or prototyping activities before they are placed on the market. So the eye of the regulation basically is, on AI that is placed on the European market. Providers of general purpose AI models shall put in place a policy to comply with union law on copyright. However, the AI Act does not regulate what that actually means. So it is up to the providers to come up with some, informal regulation among each other to make sure that this requirement is kept. With this, I would like to turn to a provisional appraisal of the copyright-related effects. And I will do that. I will state that this is my personal view and not at all binding upon my esteemed colleagues at home. And I would like to start with the idea that the reproduction of copyright-protected material for AI training, so the very first part of the whole adventure, is probably exempted by the data mining exclusion. This wasn't so clear before the Digital Single Market Act. We were all wondering how we actually would, look at AI and the use of protected data. But since in the Digital Single Market Act, as I cited before, these data mining exemptions are regulated, and also the AI Act refers to the data mining exclusion as a possible tool, we can probably say that this exemption is applicable at this point. Now, you have to prompt something to the AI so that you get a result. You might use copyright-protected material while prompting, and I would guess that this probably is a transient reproduction, so another exclusion would apply. And then we come to the more sensitive issue of reproduction of copyright-protected material and the output of AI. And this is probably where we will start at some point with our case work. Because, as I told you, if a user doesn't have the right of use, the reproduction is only allowed if an exemption applies. And so this is probably not temporary, because this is a permanent result that we want to, put on our wall or do whatever with it. The exemption for text and data mining probably only applies for the training phase. It is also not an incidental inclusion. It is practically the whole point, probably, of the result that you probably recognize the protected work. As AI doesn't quote as of today, quote meaning also making visible your source, the exemption for quotations probably wouldn't apply. Maybe the exemption for the purpose of caricature, parody, or pastiche might apply if you have this kind of material coming out of the AI. And then you have the exemption for private use, and that probably is applicable. And the question arises: shouldn't the copyright holder be remunerated for, their work that has gone into and come out of the machine? This is an open question because the AI Act doesn't confront this issue, and the EU legislator has not, as of today, regulated this point, not even as an option for the member countries. But I think this is something that we will increasingly talk about in Europe, at least. Now, what are the obligations of AI operators? As I said, the Act requires that the operators put in place a policy to comply with union law. That, poses quite a couple of questions that I have put down in my written presentation. For example, issues of territoriality, quite thrilling questions. Only to reproduction in the EU, or is it doesn't it matter whether reproduction happened? I mean, that would be the conventional copyright attitude, right? That you look at the location of the reproduction as because of the territoriality of the copyright, other reproduction wouldn't be relevant at that point. But it is quite open whether it is sufficient that the AI is placed on the European market, even if the reproduction has occurred somewhere else. Then in the training phase, the operator has to provide a sufficiently detailed summary about the content used for training. This would allow at least to have some hint as to what kind of material has gone into the machine. It's probably not realistic to expect that there would be, my work being cited in this overview, but maybe the database would be identified that has been put into the machine. And then again, in the implementation phase, the operators have the obligation to put in place a policy to comply with union law. This act probably envisages a model of that we know from other fields of IP law, a system of notice and takedown, if that is appropriate. Looking at the time, I will stop at this point, and I'm looking very much forward to the following presentations. Thank you very much.
대단히 감사합니다. 상세한
Thank you for a detailed presentation. The copyright issue, we do have the IP High Court in Korea that is dealing with the copyright. I mean, we hope to be able to cover those areas together with the IP issues, but then this was kind of being not covered so much by the High Court. But then we do have a lot of copyright-related directives in place. And you touched upon, and it also regulates some of the common use or general use AI as well, and it seems very complex. And thank you so much for the detailed explanation, and it requires further study, I believe. And next, I would like to ask Judge Kiyo Matsumoto to give us the explanation on the U.S. situation.
Well, unlike the EU, the United States has yet to pass any legislation guiding our society as to the proper uses of AI. So courts are on the front line of trying to interpret and make sense of this very rapidly emerging technology. And we often look to principles of patent, trademark, and copyright law and the surrounding cases. So in my materials, or in the materials that you have, I've got certain cases that have been summarized for you. One of the main cases, Thaler versus Vidal, stands for the principle that a natural person, and only a natural person, may be a patent holder. A fellow named Stephen Thaler attempted to have his AI system DABUS, which stands for Device for the Autonomous Bootstrapping of Unified Sentience, recognized as an inventor. And the U.S. Patent and Trademark Office rejected this request and found that only a natural person could be designated as an inventor. The Federal Circuit upheld that decision, and the United States Supreme Court denied certiorari. So that is still the case. Moving from patents into copyright, similarly in Naruto versus Slater, the court similarly held that only humans can be recognized as authors under copyright law. And this does impact AI-generated content because it establishes a non-human creator and the principle that a non-human creator cannot fully own a copyright. And finally, in Perry versus Shine Distribution Corporation, a lawsuit was brought by a number of designers against the defendant, which was an online fashion retailer that used an algorithm to scrape the internet for fashion designs, often using existing designers' work and creating fashions based on an algorithm. So this is still in discovery. The case has been challenged in a motion to dismiss, and it's awaiting a decision. Did you want me to talk about generative AI too, Judge Lee, at this time? Okay. All right. So ChatGPT was created by OpenAI in late 2022, and a lot of litigation has arisen from that system. Generative AI produces outputs based on learning. AI is capable of learning from vast amounts of data, and concerns have been raised about copyright infringement during the AI learning and training process. So there have been lawsuits surrounding that issue. First, when we talk about AI training data and the collection of information that these AI outputs are trained to utilize, the courts have grappled with how to deal with these challenges. The cases generally fall into different categories. First of all, copyrights and IP issues, data privacy, and security questions. Regarding pictures or images, Getty Images versus Stability AI was a lawsuit by Getty Images which sued Stability AI, which had trained its generative image models to search millions of copyrighted images from Getty's catalog without permission. And the case has continued on. It is still active. Getty Image requested oral argument on Stability AI's motion to dismiss and transfer the case to the Northern District of California from Delaware, and that case is still pending. I believe oral argument did take place. Also, we look to literary works, the written word. Authors Guild versus OpenAI was a class action by different authors against OpenAI, which accused AI of using copyrighted literary works to train its AI models, including ChatGPT. The plaintiff argued that the ability to summarize and generate text and mimic the literary works of copyrighted material was an infringement. The case is still in discovery. A recent case filed by the New York Times against Microsoft and other AI vehicles like ChatGPT alleged that OpenAI used New York Times actual articles to train its model to answer prompts generally, and that in that process of training, what was generated were either exact or nearly exact copies of articles to which the New York Times held copyrights. Another case concerned music. Copyrighted song lyrics versus Anthropic. This is a music group that had the rights to different song lyrics and challenged an AI developer, Anthropic's models, which would pull, again, copyrighted music without obtaining permission. The music publishers allege that Anthropic improperly used their copyrighted song lyrics to train its generative AI conversation interface models. This was a device or an entity called Claude. It was a large language model training with vast amounts of text that it copied from the internet, totaling billions and trillions of words. And Claude claimed that it didn't merely regurgitate, but actually applied complex reasoning, creativity to its training corpus in a way that approximated to human cognition. The plaintiffs disagree, of course, and allege that Claude would get prompts and pull the lyrics, these millions of lyrics, and produce, again, identical or nearly identical copies of those lyrics. The case is in discovery, and it has recently been transferred from Middle Tennessee to the Northern District of California. The appendix in your materials does summarize some of those cases. Did you want me to discuss fair use now or later, sir? Judge? Judge Lee, did you want me to discuss fair use?
예, 공정사용과
Yes, please, including TDM. Also, if you could cover that also, thank you.
All right, as we know, fair use under the Copyright Act of 1976 requires courts to consider 4 factors. First, the purpose and character of and use of the work, whether it's commercial or for nonprofit or educational purposes. This somewhat mirrors the EU concern about commercial use versus personal use. Second, the court considers the nature of the copyrighted work. Third, the amount and substantiality of the portions used in relation to the copyrighted work. And fourth, the effect of the use on the potential market. So courts look at factors 1 and 4 as probably assigning the most weight. Factor 1, the purpose and character of the use, was almost entirely a question of how transformative the work was. In Campbell versus Acuff Rose Music, a 1994 case, the Supreme Court set aside this concern about commercial use not being a fair use, but rather looked at whether the work had been transformed and found that parody was a fair use. In that case, I don't know how many of you know the song, Roy Orbison's song, Pretty Woman. A rap group called Two Live Crew did a parody of that song using the same tune, but changing somewhat the lyrics. And the court found that there was something new that had been added to that song with a further purpose of parody. And the more that the transformation occurred, the less the court would be likely to find that the other factors were of significance. Factor 1 was also used in the Supreme Court's consideration of Andy Warhol Foundation versus Goldsmith. And there the court advised the lower courts to think about not just how much the defendant has transformed the work, but how the challenge use differs in purpose from the copyrighted use's purpose. There, Andy Warhol Foundation had sold a silkscreen, a photo of Prince, the musician, that was on the cover of a magazine, and held that that was not fair use because the photos that the original photographer took of Prince had the same purpose as the Warhol use of the same image. And when one has a risk of substituting the allegedly infringing work for the original work, then the court is going to look for relevant and independent justifications. Is there parody? Is there criticism? There, the court made somewhat of a departure from the prior Factor 1 analysis. Factor 4 is the effect of the challenge use upon the potential market for the copyrighted work. So there, we look to whether the copyrighted work itself is a derivative, is for a derivative market. An example is if an author writes a book, and then that book, without permission, is made into a movie without the author's consent, what it does is it impedes the original copyrights holder's ability to derive benefit from his or her own work. So the court will look to the impact on the market and would consider whether or not the authors continued writing new books if everyone knew that a writing could be used for a movie or some other purpose. Courts also look to public benefit. There, in Google versus Oracle, Oracle sued Google for taking whole cloth some of its declaring code and incorporating it into the API, or Application Programming Interface, for its Android phones. An API allows computer programmers to use pre-written code to build certain functions into their programs without having to rewrite or create their own code from scratch every time they want to perform those functions. The Supreme Court held that this had to be considered fair use or the public's interest would be harmed, because enforcing Oracle's copyright in this instance would lock or preclude or limit future creativity of new programs. And certainly in terms of generative AI, this issue may arise again. Factor 2 concerns the nature of the copyrighted work. This is typically not the deciding issue, but courts are more likely to protect works of fiction or creative works rather than a news article, a speech, or some existing more fact-based work. In Hatchet Book Group versus Internet Archive, the Second Circuit Court of Appeals explained that Factor 2 involves looking at as if the copyright work is expressive or creative. They are closer to the core of the intended copyright protection, which is to protect creative works versus more factual works. Factor 3 is the amount of and substantiality of the portion used, and this is whether the defendant used more of a work than is needed to achieve its purpose. So in Harper Row Publishers versus Nation Enterprises, the court found that Factor 3 weighed against fair use, where a magazine article copied the most important passages from Gerald Ford's unpublished memoir before publication, rather than summarizing it or just quoting small portions. And so there, the court looks at how much of the protected work is being used to find whether or not Factor 3 should control. Again, I refer you to Appendix 3 for a summary. Did you want me to move to training data?
예, 디테일
Yes, I think that that's about will do. So whether the copy rights can be protected on the derived work.
AI generated content. 질문 3번, 질문 넘버 3.
Federal courts are currently weighing whether generative AI models infringe copyrights, or alternatively, whether AI models' use of copyrighted training data constitutes fair use. There are 3 categories of such cases. First, cases regarding feeding books and articles into large language models, also known as LLMs like ChatGPT. Second, cases regarding feeding visual art and photography into generative AI models, like Stability AI. And third, there's the only case that we found as of a few days ago that has provided guidance in evaluating fair use in the AI training set context. In the first category, feeding books and articles into large language models, that was the case New York Times versus Microsoft, which concerned unlicensed use of New York Times articles in ChatGPT's data sets. The Times alleged that OpenAI not only used the materials to train its model to answer prompts generally, but also occasionally produced exact or near exact copies of the New York Times copyrighted works. So to the extent ChatGPT would produce an almost exact copy of the Times articles, this would allow them to circumvent the New York Times paywall. They extract a fee for anyone who uses their articles, and they challenged whether this could be fair use. This case is still pending, and it remains to be seen what will happen with that. OpenAI is making similar arguments in other related cases. Authors Guild versus OpenAI was filed in September of 2023. There were copyright infringement claims related to AI training data. OpenAI argues that ChatGPT only produces replicas of articles or other literary works through manipulation and misuse. In the second category, where you feed visual art and photography into generative AI generations, we have the case Anderson et al. Versus Stability AI. There, the plaintiff was a graphic artist and filed a class action on behalf of artists challenging the use of their works as training images in Stable Diffusion, which was a generative AI image generator. Many of the claims were dismissed on fair use grounds. The direct copyright infringement claims, however, remain unresolved. And the judge there held that rather than decide this at the motion to dismiss stage, it would be best to resolve this after there had been discovery and perhaps at the summary judgment stage. Getty Images versus Stability AI. This is a challenge by Getty Images alleging that Stability AI unlawfully trained its generative image model Stable Diffusion using millions of copyrighted images from Getty's catalog. They have millions of images that one may use, and oftentimes artists and other folks will go to the Getty catalog, but there's a fee, a paywall for that. The parties are fighting over whether jurisdiction and venue are proper, and there is a parallel proceeding between the parties in the UK courts. Stability AI has invoked the UK's pastiche exception to copyright, which is their analog to fair use. So the issue could have some disconnect if there are decisions from both UK courts and the American courts on this issue. The third category is the one case where a federal district court has provided guidance on fair use. In Thomson Reuters versus Ross Intelligence, Westlaw's parent company, Westlaw, you know, is the legal research tool, sued Ross AI, which was a startup, in the District of Delaware for copying its headnotes. Westlaw alleged that Ross utilized its headnotes to create questions for a series of legal question and answer memos that constituted Ross's machine learning and training. In its motion for summary judgment, Ross argued that its use of Westlaw's headnotes and key number system was fair use because users who copy material as a minor step in creating a new product are engaging in transformative fair use. The Delaware District Court denied summary judgment on fair use as it was disputed whether or not Ross used Westlaw headnotes simply to learn language patterns and produce unprotected judicial opinion quotes, which would be fair use, or whether Ross used the headnotes to replicate Westlaw's editor's creative expression. Ross argued that its use was not transformative, which is a step in the process toward a new expression, and Westlaw argued that the use was not transformative Judge Stefanos Bibas found that Factor 2 will likely favor fair use because headnotes are not close to the core of copyright, but factual determinations to come on transformativeness could still change the outcome in this case. Factors 3 and 4, including whether it is in the public benefit to allow AI, such as Ross's, to be trained.
Apologies for factor 3 and 4. Due to time constraints, maybe let the audience refer to the booklets if it's okay with you. Apologies due to time constraints. That's what we are going to do. Now, you talked about various U.S. cases, and I really thank you for that. Now, as you can see, in the appendix, we have 5. Well, up to Appendix 6, their summary of current trends and cases, which will be very helpful to various practitioners. Next, we'll move on to the Korean context, and that will be presented by Mr. SOHN. And 10 minutes, please. Thank you. Hello, I am Young-Eon. I've been working in the IP High Court of Korea till February this year, but then now I am working at the Andong branch of Daegu District Court covering criminal cases. I'm very pleased to see you all again. And as you are all aware, the AI is such a big topic in all the field, including the IP area, so I am very honored to be part of this session. And due to time constraint, I will jump right into the presentation. And I would like to say before I do that a lot of the good information was given by the earlier 2 judges, so I will skip the parts that are overlapping and only focus on the parts that are not covered yet. And the first one that I want to talk about is the AI-related, IP-related issues in Korea. And the Davos case is such a big case in Korea, so I don't think I will need to go through all the details. But what I want to tell you is that the plaintiff lost both the first instance case and the second instance case, and it is now pending in the Supreme Court. And with the development of artificial intelligence, when it comes to especially the IP area, a lot of different questions and discussions will arise. But now I think we are still at an imagination stage. We cannot really clearly tell what the results will be like. And this was actually touched upon in the earlier session, but as the AI is more widely used, we will need to adjust the level of the skills that are used by the FOSITA, so that will still need to be, defined. And how much of the contribution assessment should be done for the inventor when we are calculating the invention award is something that we will need to also think about. And as the artificial intelligence can analyze a huge amount of data in a fast pace, we will be able to see the previously non-obvious invention becoming obvious in the future, and that will actually have an impact on how we are judging the inventive step. And it's really hard to predict the future, but we will always have to be very interested in this topic to be able to be ready when we need to face the issues that are directly related to AI. And now let me move on to the copyright infringement related to AI. We don't have such a case in Korea yet, but as the Gen AI, including ChatGPT, is widely used in South Korea, and many Korean companies are also using and developing new AI platforms and engines. So I am sure that there is a possibility of having this type of litigation in the future, even in Korea. And when it comes to the copyright infringement suit that could be brought about related to the artificial intelligence, we will have to think about whether the fair use provision can apply. Korean jurisdiction also applies this provision, but the key details are laid out in the booklet. And according to the provision, this is very similar to that of the U.S. It shouldn't be colliding directly with the general use of the work, and if it is not undermining unfairly the fair and reasonable profit of the author, then you can make use of the work. And when you're making a judgment, you will have to consider the purpose and the characteristics of the use and the type and the purpose of the work. And thirdly, you will have to consider the importance and the percentage of the quote having in the whole of the work, and you also have to consider the market value and so forth. And recently, there is one case where the Supreme Court talked about the criteria of the fair use provision. So let me share with you that. The plaintiff here in this case was a copyright trustee, and the defendant was a company that made the academic tests, and the defendant actually uploaded the work that included the copyrighted material of the plaintiff, and the plaintiff filed a suit against the defendant saying that the defendant infringed upon the copyright that it had and sought damages. And there are details, but let me skip the details because that is available in the booklet because of the time constraint. And the criteria that was used is slightly different from the U.S., so please refer to that in the material, please. And to give you the conclusion, I mean, in this case, the Supreme Court held that the disclosure or the publication by the defendant had the public interest aspect to it, but it held that it cannot be considered, the publication cannot be considered transformative. And secondly, the defendant did not receive permission from the plaintiff, and it did not put in place the prevention of reproduction prevention mechanism and just published the work online. So the Supreme Court held that it is difficult to consider that it is the fair use of the work. So this is going to be a very important case that we will have to consider when we are thinking about the copyright issues related to the artificial intelligence training data. And let me move on to the next topic, which is TDM, text mining. I will not give you, I think, detailed explanation of what text mining is, but in the process of analyzing a huge amount of data, you are collecting and analyzing the data, and the reproduction action that is engaged in the process, is it going to be causing any copyright issue? That is a really important question. And we did have in Korea have discussions about the TDM waiver being newly included in the legislation. We did talk about that as part of the bill as well. And there, the revisions, the proposed revision drafts actually apply a really limited scope for this exception, so that the rights of the copyright holder can be protected, and while the development of the AI can still be pursued. But about the bills that are proposed, there are criticism that the definition, the narrow definition that was given, was still ambiguous. Unfortunately, the bills are not. The bills were scrapped because of the end of the Congress term, but I think this type of discussion will continue to be held in the future. And let me move on to the next topic, which is the royalty with regard to the AI training data use. So as the AI technology develops and the AI-based content becomes more commonplace, the remuneration to the copyright holders will need to be made in a reasonable way. It seems clear that it is needed, but this is the area that still needs further discussions. Nothing is clearly decided yet. And personally, if a work is used for the training of an AI, it is not exactly like a traditional use. It is not, felt or enjoyed by its emotions, or the thoughts are not directly felt or entertained. So, if the same kind of approach is used for the royalty calculation, it may not be reasonable. So it will have to be thought of in a slightly different way. And in terms of how the remuneration would be made, I don't think that there are many discussions held in Korea. I mean, we do have some discussions taking place, but it's not very much. But we will have to think about a balanced way where we can still protect the rights of the copyright holder, but still can incentivize the development in the AI industry. And lastly, I would like to talk about whether the copyright can be acknowledged for the output from the artificial intelligence. Well, as in the US, in Korea, I mean, the copyright or the work, the nature of the work cannot be acknowledged for the output that was created by the AI, and the AI in and of itself cannot be the author either. But if there is the, for example, adjustment or the reduction or the increase or the editing to the AI's output, then and there the creativity of the human being was involved, then on that one the copyright can be acknowledged to a natural human being. And I do have some examples here, but please refer to that from the booklet. So this will be the end of my presentation. Thank you.
네, 대단히 감사합니다.
Thank you. That was a limited time, but thank you for the summary. And I would like to once again give a summary myself, because this can be a rather confusing topic. I mean, AI is collecting training data, and it uses it for training, and they say that they delete it. So you will be using it for the prompting purposes, and the output that you get is actually a creation from the AI. It's not the direct use of the source material. That's what the AI operators say. So we have two questions. I mean, when that is used for when the material is used for the input, is that the infringement of the copyright? And most of the discussions focused on this first part. There, that's related. We do have the reproduction related question, and the TDM provision was actually legislated in Korea even before the in the US. It was legislated even before the ChatGPT, and we try to do that too in Korea, but then it is met by a strong resistance. And the next one, the second question, is around the output from the AI. And as everybody explained, I mean, there are a lot of different aspects to it, and there is a question of whether the output is infringing upon a different copyrighted work. So they say, the operators say that the materials that are used for the training is deleted, but then that actually gives rise to a different problem too. And another question at the output level is that the output in and of itself, can it be protected as part of the copyright law? And many view it like a camera, and that is a starting point of the discussion. So if the output is predictable, maybe this is a means. And how detailed should we be when we are writing the prompts? I mean, these are the questions that are raised when we are having the related discussions. And please have a look at the booklet for detailed information that the panelists were not able to deliver to you in person today. And let me move on to the part 2. Part 2 is an even wider topic. So how to use AI in legal proceedings. So the Supreme Court in Korea is very much interested in this topic. And we have given the questions like the following. So you're using the AI, and where can we actually use it? In what field? And many countries will have different ideas, so we're asking what the views are in different countries. And the second question is around the potential challenges. Security, privacy could be potential challenges you may face. So what are the solutions that you have in hand? And in the US, we had the Compens case too, so we would love to learn more about those aspects as challenges. And the third thing that we would love to learn from you is if there are any bill that is pending or any regulation that is being drafted related to this, we would like to learn more about that as well. And there is some discussions around making it obligatory to write down or disclose the source when the materials are used for the AI. And we also would have to, ask like small questions like what will happen to the legal professions and so forth. So on all these aspects, I would like to ask you to give a comprehensive answer. And the first one to answer would be FEDDERSEN from Germany, and I will give you 5 minutes.
Thank you very much. Now, I'll start with what I know best, that is my own job, being a judge. And the question arises whether we can imagine something like automated decision-making. And the answer to that is quite clear. We might be able to imagine it, but whether it is admissible is a completely different question. Because, and I'm speaking now from a German point of view, having our constitution in mind, judicial power is, as of the constitution, to be exercised by human judges. Therefore, I would clearly state that the substitution of human judges by AI is just illegal. I have put down the relevant provisions in my presentation in the booklet. I'd like to mention that the European Union holds a similar point of view, because in recital 61 of the AI Act that I have spoken extensively about provides that the use of AI tools can support the decision-making, power of judges or judicial independence, but should not replace it. The final decision-making must remain a human-driven activity. And that leads me to the second aspect. What about assistance in preparation of decisions? And I would say that, and I think that is a view that is quite common among German judges, you could imagine assistance in preparation of decisions by automated systems, as long as the human judge is the one who has to take responsibility for the decision, knows and controls the substantial and procedural basis of the decision. And that, of course, is a problem if, and maybe because, and if, I don't know, maybe that will change at some point. But I think as of today, AI does not guarantee transparency, explainability, and verifiability of results. The black box problem, and I would clearly say that I, as a judge, cannot take responsibility for a black box judgment. There are also strong reservations towards AI among my colleagues as far as criminal proceedings are concerned. We think of the risk of implemented discriminatory tendencies, lack of fairness, insufficient transparency, objectification of defendant, if that is meaningful. Assistance, yes, but as I said, we need transparency, explainability, and verifiability of results. Another aspect I'd like to cover is the question, and unfortunately I will keep my remarks very brief at this point. What about application of AI assistance in German judicial procedures as of today? And I must say, as of today, there is no standardized operation of AI assistance in German judicial procedures, but at least there are several projects that aim at the development, the experimental application of assistance systems. It starts at a rather basic point, I would say, extraction of metadata, running keywording and research databases with the help of AI. And now it gets more interesting because we have quite a lot of mass proceedings. you know, I'm a little shy of mentioning the word diesel scandal here, but I mean, you probably know what this is all about. And the German courts are basically, you know, overwhelmed by a tsunami of diesel proceedings. Even my court nowadays, because at some point, you know, the courts of lower instance have done their work, and then it ends up at my court. And we have the challenge, you know, and we have talked about this and heard about this before, you know, huge amounts of pages and thick files and so on, how to deal with that. I really would welcome software that helps to recognize text patterns, at least, because law firms, big law firms, very often use text patterns and put them together in a rather I would say, unique way, and you'd like to find out whether this case that you have before you really is different from the one that is next in line. So this is something that could really help us, you know, recognition of text patterns and structured presentation of pleadings and arguments. So in my view, this is the most desperately, you know, longed for AI solution that we really need to cope with certain kinds of proceedings. Well, also, maybe not so important, chatbots for information, anonymization of court decisions. We have talked about that aspect in some time at this conference. Could also be done by AI, maybe. Thank you very much.
네, 대단히 감사합니다. 뭐 시간을 잘 지켜주셔서 대단히.
Thank you so much for keeping the time and for your insight. And I would like to move on to the next speaker, Judge Matsumoto.
Use of AI is not that common in U.S. courts at the time, but our Chief Justice of the United States Supreme Court has recognized that AI has the potential to make courts more accessible to pro se litigants, that is, people who cannot afford a lawyer. The flip side concern, of course, is that we will be flooded with a lot of lawsuits if AI is permitted to be used by pro ses. Like Judge FEDDERSEN, we are very concerned that the judge's function is a human function. We are to exercise our judgment, our humanity, our compassion, and our legal analysis in deciding issues of importance. So I don't know that judges will become reliant on AI. I think part of the problem is when conducting legal research, AI can hallucinate, which is the false information or incorrect citations. It could also rely on biases, both racial, socioeconomic, and otherwise, to result in unfair findings. In one case, a judge in my circuit, Judge Kevin Castell, sanctioned two lawyers $5,000 each because they submitted a legal brief that cited a number of cases, but lo and behold, when Judge Castell and his clerks looked at those cases, they were completely made up. So although lawyers may use AI, it is really a good idea to check and make sure that you're citing real cases. I believe that Michael Cohen, the famous former lawyer to Donald Trump, and who's already been disbarred, mistakenly provided his own lawyer with fake cases created by a program when a motion was submitted to federal court. With massive amounts of data being exchanged in discovery, AI can assist in sorting and searching for relevant information, and AI certainly can help with voluminous trial transcripts and searching keywords and that kind of thing. Judges would be loath, I think, to use AI to calculate sentences, bail risk, and recidivism risk, because there is an argument that AI is not very transparent, and a defendant who's facing the loss of liberty has the right to understand what factors a judge has considered in deciding whether they maintain their liberty. Human oversight is always going to be an important factor. And when deciding risk assessments, again, the courts have to be very careful that whatever algorithms they use are not going to have implicit bias in them. So I think that is probably where I will stop. With plenty of time, hopefully for you.
예, 대단히 감사합니다. 대단히 감사합니다.
Thank you so much. And you have given us such a in-depth material, so I ask everyone in the audience to read them afterwards. And I believe Judge Kwon have prepared a lot, but could you please give us the presentation in 5 minutes?
Yeah. Hello, everyone. We are almost there. It's truly an honor to take part in this conference and this session, and at the same time, it's a burden to be the very last presenter in front of all the tired faces. I actually prepared a fancy slide which would last for about 20 minutes, but I cannot beg for your more effort and time, so I think I'll just skip some of the parts really quickly. Actually, my slides was to be divided into 2 parts to give some technical insights on AI in legal context. This is drawn from my previous slides. I often give lectures to lawyers, judges, or law students, but I'll just skip the first part. And we will straightly jump up to the second part. I'd like to explore how the Korean judiciary is working to adopt AI technology. Just look around what I've prepared for. Machine learning, how different concepts of AI, machine learning, artificial neural networks, deep learning relate to each other. So there's a concept of rule-based model and learning-based model. It can be compared to a civil law system and common law system, actually. Civil law system heavily relies on codified statutes, while common law is developed from case precedents. However, this is not the case for today's world. And machine learning and artificial intelligence these days do not really purely rely on machine learning. It also has code-based, rule-based code within them. Machines perceive the world in the forms of zeros and ones. And you see the Python code, which the artificial intelligence really is, you'll see all the arrays of numbers. And the AI converts words into numbers by technology called word embedding, which is so when you convert words into numbers, you can actually plot the words into imaginary spaces, and the distances will reflect the relationship between different words. And from that, we can actually pick up a context from words. So what it really means is that machines just adjust numbers. They do not really recognize variables as humans do, often with bias like race or gender. And at the same time, they cannot, if data is not given as input, they cannot consider them. And even certain attributes like race or gender to avoid, let's say, to avoid discrimination, they will still find certain indirect relationship and pick up as at least influencing factor. This is sometimes called proxy discrimination. What AI actually do is sometimes divided into 2 categories: classification and regression. Classification is to divide categories, and this is what we do in legal decisions as well. Like in criminal law, criminal cases, we decide on guilt or innocence, while sentencing being regression, which is to evaluate numbers. And it's the same in IP law. We decide on novelty, inventive step, or non-obviousness, likelihood of confusion, but we also calculate damages. But while AI can do these kind of tasks, fact-finding should precede those tasks. Which means we need to extract relevant information from complex records and decide what to input as data. And while a machine being not able to pick up on human intention, credibility, contents, or at least if it's not input as data, or it's still challenging for machines. So the full automation of decision making is not quite within immediate reach, I would say. And aside from those two tests I mentioned earlier, classification and regression, AI can also generate sentences, which is just to generate probable sentences according to criteria of coherence. A researcher, a professor in University of Washington, Emily Vander, once mentioned that, referred to AI as a stochastic parrot. So we need to take that in our minds. Now let's briefly explore how what Korean judiciary is doing to adopt AI into their system. So you might be already aware of Korea's e-litigation system. It's come quite a long way since 2010 with patent cases, but it's become outdated and complex. And next generation e-litigation project is to streamline and modernize the system with AI with AI tools incorporating AI tools in that, and it's under testing phase with service to launch soon. So one key feature of this project is the intelligent search model, which enhances search relevance by utilizing natural language processing and analyzing user behavior, for example, log data to recommend similar cases. Another important aspect is the issue extraction model, which organizes arguments in tabular form. Judge Sugiura mentioned this kind of thing earlier today, and highlights repetitive content to allow judges to avoid from reading repetitive content and connecting written arguments to related evidence. AI also supports case management, and this project also includes automated error detection and advanced calculation tools. Another significant aspect is improving public access to justice. The litigation assistance will provide 24/7 guidance for litigants and enhance accessibility for people with different abilities and facilitate better communication between courts and litigants. Plus, there's a predictive model that analyzes documents to suggest early settlement options, aiming to resolve disputes sooner. To ensure the reliability of such technologies, the Judicial Policy Advisory Committee, an advisory body that deliberates on judicial policy, which is proposed by the Chief Justice, has recently issued recommendations on AI use in judicial proceedings. And members of the Association of Korean Judges for AI Studies are also drafting guidelines for judges. Let's take a look at some specific legal and ethical challenges that AI introduces in judicial proceedings. First up is bias. This often comes from data than algorithms themselves.
우리 검사님 죄송한데
Apologies due to time constraint. If you could finish up within 2 or 3 minutes, that would be very much appreciated.
마이크를 네.
Accountability, privacy, and security will be also a big concern. In legal education, so to look ahead, emphasis on AI literacy, ethics will be included in legal education. It will probably influence legal professions for newly started lawyers to have difficulties in finding opportunities for traditional training course, but at the same time, AI proficiency becoming a cutting edge. Like someone once said that wise men will become wiser and narrow-minded will become even more narrow-minded. And judicial administration will strongly rely on data-driven decision-making. Thanks for your attention.
예, 모두 발제자분들의 너무나 좋은
Yes, I mean, I can tell they have a lot to say and they're so insightful, but I am sorry that I was only able to give you a limited time for all the panelists. So this would conclude this session 5. Well, we were expecting to have the Q&A session at the last, but then we do ran out of time, and this is actually the topic that we cannot really give you the clear answer as of now, so that is why we would like to skip the Q&A for today and hope to have this session as the first session maybe in the next conference. So, and please have the discussions afterwards so that we can share our thoughts about this topic as well. And if you don't have any additional comment, we would like to wrap up the session here. Thank you so much for all the input.
네, 좋은 말씀 감사드립니다.
Thank you so much for all the contributions. Please give them a big round of applause once again.